Dan has a background in information modeling, database systems, content clustering, analytics, and technology-assisted review. He broke new ground in e-discovery with his solutions for collection, processing, and review of content from collaborative sites such as wikis, SharePoint systems, and social media sites. Into his software design work, Dan also manages large document repositories for our GGO enterprise clients. Dan oversees forensic investigations of computer systems conducted in GGO's forensics labs in Seattle, San Francisco, and New York. See that he has a really insightful way of communicating technical ideas to less technical audiences, and that serves him really well, as he's often served as an expert witness in matters related to e-discovery technology. Second speaker today is David Horrigan. He's with 451 Research. He's an analyst covering electronic discovery and information governance. His include legal and industry developments as well. An attorney and a longtime legal technology writer, David brings both law firm experience and years of technology writing to his analysis of these growing industries. David advises clients of 451 Research on the rapid changes happening in e-discovery for corporations and law firms, helping them keep pace with regulatory requirements and information management demands. Prior to joining 451, David served as assistant editor and staff reporter at the National Law Journal and as a columnist for Law Technology News, writing the long-running Technology on Trial column. His articles have appeared also in American Lawyer, Corporate Counsel, the New York Law Journal, Washington Examiner, and others, and he's often cited in law reviews and journals of Emory University, Northwestern University, Yale, and others. He also managed e-discovery projects for the international firm Covington and Burling and has advised Brown University on their implementation of e-discovery records and governance policies. That's quite a lineup. Whether your questions today are technical or more in the legal realm, we've got two of the best experts ever who are ready to tackle them. So I'm looking forward to this myself, so let's get started on our presentation. Why is it important we address this topic of technology-assisted review? As we know, and it is often cited in the press, more than 98% of custodian content is now created in digital form, and the digital universe is estimated in 2011 to be at 1.8 trillion gigabytes, or 100 quadrillion files. I don't know if you can even imagine what that volume really means. As we know, when it pertains to e-discovery, keyword search has proven to have known limitations. The number of projects in document review research have revealed. So keyword search still has its place. Technology keeps evolving, and advanced analytics and data mining that are being used to identify patterns in data and support business decision-making, or to understand your interests and preferences on the web, for example. Who hasn't been on a website or in their Gmail account and get suggestions in the borders of what book or restaurant you might like? It seems natural that similar technologies, as they advance, are also well suited to help us glean out the important facts, issues, events, and find the most important documents in an e-discovery matter. So I'm going to start with you. We have probably a mixed audience today, and some of our attendees may have little familiarity with the technology behind technology-assisted review. Can you start by explaining what TAR is?
Sure, we'll give that a shot. But, so the idea behind TAR, and the assisted is the important part of it here, is, you noted, a technology that can help us make sense of the documents or the corpus we're about to address. And the TAR is not new. I've been working with these technologies since I founded 10x 10 years ago. Really, we've had great success with our clients, but there are obviously some pitfalls you kind of have to be aware of as well. Questions I actually get most often with respect to, what is TAR, really boil down to, one, how does it work? Or two, what should we pay attention to And so I think before we proceed with the, what tends to, let's talk a little bit about an analogy that I helps the problem, and I call it the puzzle analogy. So to understand how things work, consider you have a 5,000-piece puzzle that comes in a box. Right? It's assembled, we'll have a majestic landscape scene with mountains and rivers and trees. Here to start, what we have is a box of jumbled pieces. And now, in essence, to assemble those pieces into a coherent picture. Now, this is just a review process that I'm drawing an analogy to, and the pieces here obviously represent documents. But what's going to take away from this is that each piece is unique in its shape, its color, but ultimately how they interconnect tells us the story. The question becomes, how do we best go about solving this puzzle? Well, one thing we could do is we could just start by pulling pieces out of the box and eyeballing whether they fit together. But I can intuitively, that's not a great strategy for solving the puzzle. It's not a puzzle of this size. And this is where technology from TAR or TAR-type technologies come in to help us. They provide is a different way to organize the pieces into groups so that we can develop a better strategy with ultimately spending less time looking at unrelated pieces. Focusing on the items that are related to each other focuses our attention and gets us through this problem in a quicker manner. Okay? In circumstances, can reduce the total time, in essence, by assisting us in being very focused on how to complete the puzzle. And then time in setup and training, but hopefully what you're gaining back is a reduced effort on the view side, which again, as we all know, is very large as well. In terms of the cost of a review and moving on. Let's talk about the technology specifically. So what I want to point out is two things. There are different technologies that can be used for what people generally call TAR today, but there's that's been happening. Okay? And what it comes to is a decade ago, we would approach this problem by using what was called clustering. Now, this is the equivalent of grouping the pieces together by, say, color. That certainly helped because all the leaves were green, was the grass, and all was blue, but so was the sky. So the thing worked a little bit better, but it didn't really get us where we needed to go. It only so far. Well, we then made a shift to what's called latent semantic analysis. A pretty big jump because it started looking at patterns between documents, not just the simple properties of the words or in analogy the colors. We're looking at how documents and words work and interact with each other. As relevant words start popping out. So a mathematical technique, start looking at, say, colors and edges together. That is a much better correlation with what's relevant. The problem is, in LA, it's just the numbers. And those necessarily translate between matter. So it's not intuitive. It didn't give people insight as to why the system was grouping things. Clustering ended up with not really understanding why it chose those patterns. To that up, the Institute probabilistic latent semantic analysis, which is just PLSA. The great PLSA is it gave a solid statistical foundation, meaning the math behind it much more rigorous. Actually begin to compare apples to apples, if you will. The result pieces started to compare each other were actually related in a pretty meaningful way. Okay? And they made comparisons which are things like 80% like a mountain, whereas this 20% like a river. Given piece now actually had something human, we could understand how it fit together in various buckets or groups. The problem was, or is, if you will, is that PLSA is a large cost, obviously a setup and training effort, and known problems behind the math, which are scaling effort, means as the purpose grows bigger, the effort it takes to get through it gets very large, and it has an overfitting problem, really focusing on details that aren't relevant and try to tease patterns out of that. Doing more work, especially if you're a non-expert operator. So the work that you had to opt this thing in order to not get it to give you results that was specific. Everyone's heard stories of tools that don't settle down, for instance. That's the PLA sort of overworking the problem. Okay. And the other problem is it can be a little bit tricky if, imagine we started with only half the pieces in the box. Half came tomorrow. Well, the tool needs to make assumptions, which the PLSA is sensitive to, which means you have to retrain the whole set when the wave of data comes, the second wave of pieces. Okay. So this technology then, LDA, which is late direct clay analysis, was developed basically to address those issues that I just talked about. It generates a series of topics, which are groups, and they'd like, in our analogy, like mountain pieces or pieces. Doesn't mean a piece necessarily has to be one, but it gives them a broad notion of the area, the whole big picture we're trying to put together, how things fit. Okay? And what this does is allows us to direct the review in a specific area of related items. The fact is, it's not sensitive to the waves of data, which means what I see today is most large matters really come in sections. Very few people get the entire set of data up front. They probably then move on. Whereas they get a certain amount of data, and they collect another amount and another amount. And so what LDA allows us to do is not have to invalidate the older patterns as new data arise. Of course, this is all toward the goal of greatly reducing the time and effort it takes us to understand and work with the corpus as a whole. So today, or any of the earlier ones, allow us to organize the corpus, then we attack it in a meaningful way and assemble the pieces that are relevant without being affected by the ones that don't belong together, and getting to the coherent picture considerably quicker. That's how DO offers LDA to our clients. We've transitioned to that because we find that it's the best of the technologies. Find any of these technologies in any tool that's out in the market today. Okay.
That's important consideration, Dan. If people are evaluating or trying to select a technology for technology-assisted review, is to know what that underlying PLSA, LSA, or LDA is being used.
It is. I believe it is. And it isn't important, and be clear here, it's not important to understand how the math works. You're trying to get people to become mathematicians. But what's important to understand is that each of these systems has a trade-off and an advantage. Evolved over time. Some of the earlier ones have more trade-off than they do advantages. But you don't want to end up buying a tool that's billed as 10 years ago when you have a populated one that's TAR version today. So understanding what it's doing and what it is solving is what's to you, because it has to fit into your process, how the math works. Okay? And later we'll talk about how or David will talk about how the legal industry is connecting with that. What's important is the sense of how this tool is going to benefit you. It's very equal, to be honest, or technologies are very equal, if you will. Let me wrap why TAR is relevant then, if we could, just to kind of go through it. What you do, context, is you want to find something that creates into results. Again, what about the topics? Is they're very meaningful to people, uses of words that groups that help you really understand your corpus. Anything like an LDA technology that produces intuitive results, that's what you're looking for. You're not looking for something that just claims it has the answer. Other solutions or experts that can minimize the number of iterations it gets you to a set of picks or a set of groups which are meaningful to you in your review. Now I'm kind of skirting the notion of cost and effort, but if you spend time working the problem to set it and it takes you to solve it, you haven't really done anything. And so the reason these tools, all of them were actually invented, was to get through large matters, right? Literally, mere review just wouldn't be possible. But the we talked about at the beginning, just maybe you can put a people or sometimes a large set of people down and have them review through a meaningful time frame. So again, to divide and conquer and create this where we can get these things done. Good results look for the cost training and the iteration and, the ability to use an expert are to outweigh the benefits, and recognize it's kind of geared toward larger matters in general and how it works.
So the bunny puzzle isn't going to need this kind of tool.
Exactly. So, differently, if you're, if I'm looking at my kid's My Fuzzy Bunny Puzzle, to train the system to figure this out would really be silly, because we do this very quickly, and more effort and more cost is necessary. That line, and I'll speak briefly. Imagine if you had a client that you told, I need to spend $50,000 in TAR analysis before I even begin review, but the total cap was $100,000. I'm not going to fly with them, because you're clearly going to go over your budget, right? Well, gigabyte pricing can really add up here, and if you're with a vendor who does gigabyte pricing, you need to pay attention to that in defining what's large or small. Valves that don't charge by gigabytes, maybe you can try it with smaller ones. There's still going to be a diminishing return in less than 20K docks. A thumb, because the small is a very large is pretty obvious. We can all know that the average of 20 documents in a review, that's going to be large. All can be weighted by what are the potential damages, what's the real effort in terms of overall review. A small number of documents that's very complex benefit from this technology. Ultimately, this is a risk decision you're making, which have input from your project managers. That's going to best benefit you where the cutoff point is. But technology designed as well fits all. A last note on that is, nor is it a technology that is replacing your review process. This is not an either-or, which you'll often hear it billed as. This is a tool to help you in job done.
And that really helps. Yeah, I kind of have the urge to want to draw a black and white line on how big it's and how small it's small. And it sounds like it's a little bit of a gray area in there, but there are ways you can determine whether this is something that's appropriate.
You can, hit the nail on the head. There's a strong desire to just bucket it as big or little, but that's not the driving factor. And how it works, it does work. You have to get off is that where the cost I'm going to spend on this particular solution is going to pay off me. Because we'll find these buckets. We'll do that. We'll even do them for small corpus. But, it could be returns. Things to talk about now is if place for you to jump in and talk about how this is accepting or looking at these technologies and how it can help you make those decisions.
Shift from this look at technology towards looking at some of the legal and business issues. Remind everybody, use your little chat box there to plug in any questions you might have, and we'll address them as we move forward. Do you want to talk about aspects?
Sure. Thanks, Megan. I appreciate it. And, I think Dan set the stage really well for us about how this really affects us as lawyers, paralegals, and legal technologists. On the screen, the definition of discovery. I think everyone on this phone call probably knows the definition of discovery, but in the edition of Black's Law Dictionary, one of my favorites is that see also description, and we've got it in bold there, fishing trip or expedition. And I think a lot of people have always considered that was what discovery always was, and then as things got more modern, that's what e-discovery was. And using technology-assisted review and really put that situation into focus. You go on and examine what happened in 2006. I think it was a game changer for law and for everything associated with it in legal technology. In those 2006 amendments went in effect in December of 2006, it really made clear that, hey guys, you've got to produce your email, you've got to produce those Word documents. These are things that we take as second nature today. It really wasn't before then. And I think one of the big concerns that we at 451 Research have heard lawyers and technologists tell us is that there's a real hesitancy to jump into this technology because you don't want to be the one holding the bag when a court says, what do you mean? You're doing this and you haven't produced the documents? Or, in this case scenario for most lawyers, is that the technology has caused you to produce a document that you shouldn't have produced. And that's why the Rule 2065B clawback was a very important development in the '06 rules. And we've got on there clawback light. It's a lighthearted reference to the fact that we're all obsessed with the Federal Rules of Civil Procedure. When we talk about the rule changes, these were the rules that brought us the definition of electronically stored information, ESI, another term we banty about that we think has been around forever, but of course it was a term of art developed for the 2006 rules. But what's really, I think, very important is if we move on to the Federal Rule of Evidence, Rule 502, and two specific parts of Rule 502, 502B as in Bravo and 502D as in Delta. 502B, of course, is the rule that is going to protect the privilege. We were fine under the Federal Rules of Civil Procedure because that would allow us to claw back those documents. However, it didn't do anything about the privilege. There was always the situation you could have waived the privilege. That is where the Federal Rules of Evidence help us. If we move on to the next slide, we'll be able to see some of the information on the Federal Rules of Evidence 502, and there's B as in Bravo. You've got to meet that two-pronged requirement on this disclosure. And those, if you're producing a box of documents the old way in a banker's box, or through technology-assisted review, you've got to, first of all, it's got to be unintentional. And then you've got the two provisions in sub 2 and sub 3. You've got to have attempted reasonable attempts to prevent the disclosure and prompt and reasonable steps to rectify the error once you've made it. So we've got those two sections, but it's really a three-pronged process. Unintentional, you had to have taken reasonable attempts to prevent, and you've got to have prompt steps to rectify it. If we next slide, that's showing us 502D as in Delta. And this is an important one. I think U.S. Magistrate Judge Andrew Peck, who handed down the landmark to Silva Moore opinion, we'll get to that in a second, has two important observations on this, he said recently. Number one is that 502D is sort of like the get-out-jail-free card for inadvertent disclosure. That's where the parties can go in, get a court order ahead of time before you engage in your technology-assisted review, and have the court sit down and you just agree on things ahead of time. And this is a quote that I think really hits it home. If you're looking for a 502D order, it's close to malpractice. And I think that's a very good point, something we should always remember as we get into technology-assisted review. There's a recent development that is really important, and those are the changes to the American Bar Association Model Rules of Professional Conduct, specifically Rule 1.1 on competence. The new language is, in addition to that a lawyer shall provide competent representation to a client, it adds that the lawyers, quote, should keep abreast of changes in the law and its practice, including benefits and risks associated with relevant technology. If you go down to the comment, specifically comment 8, it's once again going to reiterate that you've really got an obligation to learn this technology. And language in that comment 8 is to maintain the requisite knowledge and skill. Lawyers should keep abreast of changes in the law and its practice, including, as I said, the benefits and risks associated with relevant technology, engage in continuing education and the things that we all do anyway. Now, not to scare everyone, I think Dan made a very important point. No one is expecting lawyers to go in and be able to explain the mathematic and statistical algorithms that are employed in technology-assisted review. You don't have to go back to grad school and get a PhD in statistics to do this. I don't think anyone is going to interpret the model rules to say that you've got to do that. What you've got to do, as Dan pointed out, is know the differences in the technology. And that's an important thing. Know each one of the technologies can best benefit your client and your client's case. And I think that's something that we really get wrapped up in the whole black box transparency issue. There's been a lot of commentary on technology-assisted review vis-a-vis the lawyers saying, well, no, I can't get on the stand and explain this technology, so there's no way I can use it. Maybe I am just not as technical as other people, but frankly, I've never met a lawyer who could explain the technology behind keyword searches. Keyword searches are used every day in courts of law all over the country. So I think it's an important distinction here. You couldn't explain the technology behind keywords. You're not going to have to explain the scientific algorithms in the probability and statistics of technology-assisted review. You just got to have an understanding of the technology. That really, if you take anything from this discussion today, it's that you really just need to be well-versed in this technology, but you don't have to be a subject matter expert on the nuts and bolts. Now, I think we've all seen the electronic discovery reference model, the ubiquitous EDRM, that appears at every e-discovery conference and every time this subject comes up. We then hear something that a lot of you have probably also seen, the information governance reference model. And one thing that's important here, notice the circular nature of this slide and this graphic. And I think it hits an important point home about technology-assisted review, because what's really showing is that this is an application and a technology, actually, frankly, a series of technologies that can be used throughout the litigation life cycle. We call it technology-assisted review, emphasis on the review, but we really need to remember that it can be used for early case assessment. It can be used throughout that litigation life cycle. And I think the EDRM, or IGRM, I should say, really points that out. One of the big things that comes down, why do this, is cost. And if we look at this slide, I've got these figures from the RAND Corporation study that came out this year. That's actually really good reading. It's downloadable from RAND Corporation. I recommend it to everyone. It really goes into a lot of detail on some of the e-discovery costs. Now, one thing, notice that we've labeled this sample e-discovery cost. This is not saying that review is going to cost $17,000 in every IP case, or that massive $22.1 million in every product liability case. Those were just some sample costs. But the fact of the matter is, if you can get those kind of costs in any matter, it's a cause for concern. And then if you look at that breakdown, Rand's study came out that review was 73% of what that cost was. And so something's got to give. We're going to touch on this a little bit later in the presentation, but there is what I think to a large extent is a hyperbolic concern about computers taking over for the lawyers. It may have an impact on contract attorneys coming fresh out of law school. But one thing, point number two, if we can hit home and if you take anything from today, is that this technology and these series of technologies are not replacing the lawyer. I think Dan made a good point when he stressed it's technology-assisted review. The lawyers, the paralegals, and the legal technologists play an important role in this process all throughout. The very nature of the technology, it's an iterative learning process where the technologist, paralegals, and lawyer involved gets the process going and helps it run. So that's one thing to remember. And another thing that I like to tell audiences when I speak on this topic is, Megan said earlier, the levels are increasing exponentially. Law school in the country, in the world for that matter, could not churn out enough lawyers to review this data in the custom-made linear fashion that we've all grown used to over the years. So the technology is really assisting this, and it's not really going to replace your lawyer. Legal concepts. For the lawyers and the paralegals on the phone, this is probably old hat to you. But the responsiveness, the legal, what is privilege, what is the privilege log, and of course, clawback, the beautiful thing that both the Federal Rule of Evidence 502 allow and the Federal Rule of Civil Procedure 20 allow is a good thing. It's really that safe harbor. Once again, you can't get lazy on this. One of the topics of this webinar is, what does this mean for you? You can't use this safe harbor as like, all right, let's just turn on the button on the machine and we'll see what it produces. Number one, it's sort of like when the judge instructs the jury to disregard something. In a way, the toothpaste is out of the tube. You don't want to have to claw back a document. You do want to preserve that privilege, though, to prevent things from getting to the jury. So the clawback is one of the really important legal concepts here. But as we discussed earlier, it takes diligence and it takes a good strategy going in, because you can't just do a data dump. Going on, if we go on to the next slide on technology-assisted review, I think Dan's hit this very well. One thing I wanted to point out, I think a lot of you already know, you're going to see a lot of different terms for this. Computer-assisted review, machine learning, predictive coding, software-assisted review, suggestive coding. There are a whole bunch of names for these various technologies. For the most part, one thing most of them have in common is this repetitive, iterative learning process where the lawyers and the technologists work together to let the process work and get stuff produced in a timely manner. As next slide, I like to add this one, the OWL 2001 nightmare, because this hits home the point that the computers aren't going to take over. We're going to have learned lawyers and technicians doing this stuff. The technology is just going to make it possible, but for the technology, we would be just buried under the explosion of data that we're experiencing. To put this in perspective, to go back to a quote from Judge Peck, this is actually in one of the footnotes from the De Silva Moore opinion we're about to discuss, and Dan hit on this in his presentation, Megan did as well. Every person who uses email uses predictive coding, even if they don't realize it. The spam filter is an example of predictive coding. I think this helps demystify it. As Dan pointed out, this is a technology and a series of technologies that's not new. It's new in the way it's being applied in legal cases. I'd like to bring Dan back into the conversation here on the seed set dilemma, because we had a lot of people talking about seed sets or no seed sets. Various vendors have disagreements. Experts in the field have disagreements. And Dan, I'd like to get your thoughts on this.
My thoughts with respect to seed sets is, well, number one, back up a minute. A lot of this is trying to understand how you have confidence the technology works. Ultimately, that's what it boils down to me. It doesn't necessarily come through seed sets. Consider for the moment, there's often people trying to look at precision and recall of these tools. But they're also saying that the reviewers are consistent if you look across person to person. So how do you measure and say it's more accurate than another system when you're telling me that the people who are actually judging it are inherently ambiguous, right? So the trick seed set is not to worry about the fact that documents are accurately representing the sample you're looking at. And in some cases, you may not even want it to be. Random is better. What the idea is you're trying to get enough information to build a pattern that responds to. I personally think the whole notion of having to turn over the seed set to prove it was valid isn't where we're going to end up. I think it responds to a lack of understanding that the technology is just looking for patterns. And draw back to your analogy about the keywords, we don't currently send a sample of documents that fit a hit keywords in addition to ones that do. There's confidence that technology finds them where it doesn't. It's going to happen over time. Regardless, somebody starts the engine rolling in terms of training. Effectively, is what the seed set's designed to do. With sampling or a targeted pick, what's going to happen over time is people are going to build their confidence, and that's what's important here. Precision and recall, but confidence that the results coming back match. Seed dilemma, to be honest, the argument I would make when approaching the argument I do make is important how I began. It's important that the results come out, and I can show that's held don't fall into the bucket. Now, what I did is standard for any review. Okay? I say that the technology solved that for me, because again, this technology does that. What it does is it helps you get that point. So if there are questions about the seed sets, I'd be happy to answer them. But in general, I think this is more of a reaction to people's fears about new technology than it really is a problem with respect to the industry's moving or changing.
So I think now we'll move in to discuss some of the case law. There are basically 4 cases that have discussed this matter and have entertained it. And, one thing we want to remember is this technology's been in use, even in the law, for a while. And right now, we only have 4 nationally known cases where there's been judicial intervention. The first one, of course, was the Landmark case. The De Silva Moore case in the Southern District of New York, Judge Peck's decision that he issued earlier this year, that filing date, of course, is the date litigation was filed, not the date of Judge Peck's opinion. That was early this year. And this is a landmark case because it's the first known judicial approval of computer-assisted review. One of the things we should remember about the De Silva Moore case is that although there were disagreements on the methodology, both sides agreed in principle on the use of computer-assisted review. And this, I think, is significant for being the first. It's the Marbury versus Madison, if you will, of technology-assisted review. But I think it's important, we'll get to that in a second, that the parties agreed on this case. Going on to Clean Products. This is a case in the Northern District of Illinois. And, a lot of people, I think, in our industry and the lawyers involved in the discovery look at this case and it's like, man, it's that bottle rocket on the 4th of July that just was a dud and didn't shoot off. And the reason is that the real decision on this, if there is going to be one, has been postponed to October of next year. In this case, the defendant had already done a pretty big production, and plaintiffs wanted the courts to compel them to redo their production using what the plaintiffs called content-based advanced analytics. To this point we brought up, you're going to see a whole bunch of different names for this technology, or once again, I keep putting it in the singular, and that's a mistake I'm making. This is a series of different technologies, so really remember that it's plural. There are multiple technologies going on here. The reason I use an analogy of the firecracker that didn't go off on the 4th of July is that people were really expecting ultimate showdown between keywords and computer-assisted review. One thing I always like to point out is that keyword and Boolean searches are a computer-assisted review. It's just not the iterative learning technology or predictive coding that we're now talking about using in 2012. But what happened here is the plaintiffs agreed not to push the issue until October of 2013 on whether or not future productions should be done with computer-assisted review or the content-based advanced analytics. So that pushed the controversy off a little bit. They had a couple of days of expert testimony in this case, and they really were expecting Judge Nolan to be forced into saying whether or not she was going to order them to just stick with Boolean keyword searches or go on to predictive coding and get a real discussion going about maybe this is the death of keywords. Maybe you would have a judicial opinion saying that keywords aren't going to work. That didn't happen. So Clean Products has been put off, at least for the moment. Move on to Global Aerospace in Virginia. This is a case that I think is extremely significant because the case actually ordered the use of technology-assisted review over the objection of one of the parties. And this, I think, in a lot of ways, more important than De Silva Moore. De Silva Moore will always be remembered as the landmark, the first case. But let's remember, both sides, although they disagreed on a whole host of methodology and issues that aren't germane to the law or technology, they pretty much agreed on the general concept. This is a case where Global Aerospace, a case where one party said, no, we don't want this, and the court overruled it. What I also like to point out about Global Aerospace is that it's a state court case. And we've found historically that the federal courts tend to have a lot more ability to deal with technology-assisted review and technology in general than the state courts. A lot of times there's better funding in the federal courts. There is a very strong magistrate system in the federal courts. Special masters are prevalent. They also, of course, have special masters in the state courts. But a lot of times in the federal courts, you'll find very sophisticated jurists on legal technology issues that you may not see in state courts. So I think this state court bit is significant on this. I mean, 10 years ago, when I was reporting for the National Law Journal and Law of Technology News, federal courts were implementing technology and making it a priority. So keep those two things in mind about this case. Significant as the court is ordering over the objections of the party, and that it's a state court case. If we move on to the most recent of these cases, this is a product liability litigation over a pharmaceutical, the Enrictos case. This court ordered the use of technology-assisted review, and if you want to get a look at a protocol for technology-assisted review, pull up the order in this case. It's available online, and it's an extremely thorough order talking about the technology being used, the vendor being used, and once again, this is a case where the parties agree on its use, but order gives you a great roadmap on how technology-assisted review was implemented in one case. Moving forward on the legal side, we touched on this a little bit earlier. I think an important thing to remember is that technology-assisted review has been used in hundreds of matters, but we've only got 4 known matters where there's been judicial intervention. So it's something that's happening today. At the same time, I say question these headlines, and I've put 2 of them up there for you. One in the Wall Street Journal online, why hire a lawyer? Computers are cheaper. And then a Thomson Reuters post, will computers soon replace your lawyer? One, that just is not going to happen, at least not anytime in the foreseeable future. Computers are not replacing the lawyers. As Dan pointed out, it's technology-assisted review, the computer part of it, and lawyers, paralegals, and legal technologies are always going to be part of this process. And Dan, Megan, I think that's one thing that we'll also remember from the legal side of things.
Right.
Move forward on the TAR technology. I think these are some of the points that Dan has made. The technology is evolving. He pointed out that LDA was state of the art. It's got a solid mathematical foundation, and this is on one thing on which we both agree: no degree required. Dan, you've mentioned that before. I assume you're still with me on that.
I am, and kind of summary here and finishing would be the definition confused because the technologies are changing directly in response to needs and to the growing matter sizes. From the no math degree required is I know it's going to impact you because these technologies will have an effect on your workflow, but it assists your workflow. And as we've said many times, it's all about assisting you, putting this adjunct set of technologies to assist us, not a replacement set of technologies. I'm happy to answer questions, but I think I've kind of gotten the important pieces with respect to, or as a technology entity and what does it really mean as the legal world is evolving. Megan?
One question that's come across, and that is whether or not a judge may force the use of technology-assisted review tools. To a certain extent, that is what happened in global aerospace, but I don't think that is going to be the norm. I think it's significant that it happened in that case. Even in global aerospace, the judge has given the plaintiffs the ability to revisit this once the technology-assisted review is actually used and put into place. The judge, it is over a party's objection, and that gets controversy brewing and debate and discussion going on the use of technology-assisted reviews. Even in global aerospace, the court has given the party a way out. And once again, if you look at the N. Ray Actos and also Peck's order in De Silva Moore, these are well thought out, well reasoned protocols for the use of this technology. Maybe stumbles on its implementation, but frankly, there have been stumbles on the use of bankers boxes or use of keywords or anything that's been used in litigation from time to time. So I think that it's probably going to be highly unlikely that you're going to get into court and a judge is going to say, okay, turn your tar, go out and do this, you've got to do it. It's going to be the sort of well-reasoned methodology and protocol that you see in some of these cases that have held down. And once again, to reiterate, check out that N. Ray Actos protocol because I think it's very enlightening.
I agree that frequently the tone of the courts is not that you must use it, but that we're going to disallow others from using it, meaning somebody can find an advantage. We're not saying anymore that it's irresponsible to use. We trust the technologies, but they're not requiring necessarily everybody to use it. I think this is something we accept now, like we at one point accepted the keyword notion.
You're exactly right. The only I would issue that is on Global Aerospace and the Safer case in Virginia. That is pretty much what happened. But once again, the court gave the parties the opportunity to revisit it. So
right.
not
that was
exactly
clearly a specific case, but in general, would you say it's more the notion of we're accepting, not that we're forcing it?
Absolutely. I think you're absolutely right.
Questions?
One question that came through. The others, I guess we'll give it a minute or so to see if any more come through. Any other closing thoughts?
In particular, not just stating we've gone through it. It is something that I'm finding again. This is very key. I think people sometimes distinguish the mathematical notion of precision and recall with concepts. That differently large and sort of statistical things. I don't believe the Howell case by any stretch, obviously. And so I find that a good analogy to sum up fears that people have. But ultimately, what people recognize is today, a document or two can get slipped through. The real point is what we're looking at is how the bulk of them and done something that's reasonable. And so
Sure
a huge leg up with these techniques.
Gotcha. I see one question coming through on the 20% figure on keywords. Interesting. The source of that 20% quote, we've heard it at conferences and this sort of thing before. It was quoted in the Richmond Law Review article by Grossman and Cormack, and it is basically again, tongue-tied. It is based on the Blair and Marin study, and you may have seen reference to this. It was a matter where they reviewed e-discovery in a San Francisco transit incident, and it analyzed the use of keywords in this particular production, and they found that 20% back with the sufficient precision and recall to get what was required and what was relevant to the case. They noticed that the two sides used different terminology. For instance, one side called it the tragedy. You can imagine those were the plaintiffs, whereas the defendants referred to it as, I believe it was the unfortunate incident or something like that. And so that played in. But I don't think you can automatically see, keywords are only 20% accurate, because it's garbage in, garbage out type of situation, to use the term that computer scientists love to use. Keyword searching, Boolean searching, technology-assisted review is as good as the lawyers, the paralegals, and the technologists working on it. And so I think that's an important thing that we need to remember as far as that goes. So the 20% figure is not absolute. That was in one case, and it really depends on how you implement it.
Additional question, if you have another minute, you two.
Sure.
The question relates to if precision and recall against human performance isn't the right standard to use. What do you recommend in terms of developing a confidence-building QA process?
The technology side, and then David can address any legal kind of implications. But you know, the understanding confidence, if you go way back to the folks started working with statistics 400 years ago, you need to basically sample or understand the part which you're assuming to be not in the set. In other words, if I puzzle analogy again, if I have the technology, it comes up with these big pockets of mountains and trees and grass, and I'm assembling my picture, and I feel relevant, what I do is quickly go back and look at documents that it claims are not part of the system or not part of the target. And those never come back. If I literally look at them and they say, nope, non-responsive in every case where I'm sampling, my confidence is very high that the pattern works. So about exactly how many documents were supposed to come back and how many I did get back, that's a mathematical measure for later. What it's about is, do I trust that what is being returned is working for a process where you need to look at both sides of that coin. If you get a set of patterns that work, you're going to have a very high confidence that if you ask that question, you get back the right results and only the right results, with any degree of error the machine would have. Any thoughts?
Basically reiterating what you said, the sampling I think is key. And, there's the old QC process that has been done with linear review and with keyword Boolean review of document sets. We have a second pass review and then a QC review after that, or the third pass review, whatever you want to call it, where you've got the most contract lawyers or senior staff attorneys, associates, or even partners looking at this data, looking at the document set. So that is an important process. You take the sampling that's been done and you see it afterwards. And if you can go to the court and show that those procedures have been taken, just like you had to show with any other technology, I think that absolutely helps when you've got to go in front of a judge and defend your protocol.
Thank you much. I think we're going to need to wrap it up. We're coming up to the close of the hour. I'd like both Dan Sullivan and David Horrigan for joining us today. I feel more knowledgeable and more confident about technology-assisted review after hearing your presentation. On the slide here, the email contacts for Dan and David, but mine, of course, Megan at GGO LLC is listed under Dan. That's because he's our brain trust and I protect his time very closely. If you would like more information about Digital War Room and our technology-assisted review solutions, please email me with any questions and I'll put you in touch with Dan or someone on his team. We will follow up this presentation with an email to let you know an archive location where the video of the presentation can be viewed, and we will make these slides available in PDF form. So watch for an email from me. Again, everyone, for joining us today, and have a great day.
Thank you.
Thanks all. Take care.
Bye-bye.